Welcome back to Law and Crime, everyone. I'm Aaron Keller. Welcome again to those of you listening on Sirius XM satellite radio. We're going to break down the Shaun Harrison attempted murder case out of Boston. He's facing a litany of other charges related to weapons, ammunition, and drugs. He basically admitted to some of the gun and some of the ammunition charges. Said, look, that's the only thing that I'm guilty of, is basically possessing this without the proper permits in that state. Prosecutors say he did a lot more than that, though. Let's break it all down. Dan Shore remains with me here in studio. He's managing director at Kroll. He's also an attorney. And we also have Stacey Honowitz. She's a sex crimes prosecutor out of Fort Lauderdale, Florida. Good to see you both here on Law and Crime.
Hi, great to be here.
Okay, let's break this all down. Really severely competing closing arguments about the only thing that these two sides agree on is that the Reverend, who was working as a school administrator, Shaun Harrison, now a defendant, possessed these weapons and ammunition. Is that enough, Stacey, for the jurors to say, okay, we'll convict him of those three things. We think that the witnesses are shady. We don't think there's enough evidence to get him on the top charge, which is basically the Massachusetts analogy to attempted murder?
Well, listen, you never know what a jury's going to do. You know, I'm doing this for 30 years, and sometimes when you think that they're going to confess to a couple of counts, you're sure that obviously they're not going to convict on the main charge. In this case, you have the prosecutor who pretty much laid out all the overwhelming evidence that it couldn't be anybody else. I mean, the ammunition's found in the house. Their surveillance tape has the two of them together. He basically told this jury, you have the who, you have the what, you have the person. All of these things could not be coincidental. And I think his analogy to the magic trick in David Copperfield, he's basically, you know, in a sarcastic kind of tone saying, who else could it possibly be? So I think that them trying to admit to a couple of the counts makes them think that maybe, just maybe, we'll let him say that he had these things, but he didn't do the main charge. But I think the state was overwhelming in its presentation and its evidence that this is the person that also attempted to kill this individual, never thinking that this person was going to survive and be able to finger him in the courtroom.
Yeah, I mean, that was a powerful point. Dan, we talked about a couple of things earlier, and I want to inject them into this conversation. Look, the defendant doesn't have to prove anything. That's the state's burden. But a big question on a lot of people's minds is, okay, if the defendant wasn't involved in this, where was he? Where could he have been? We don't know the answer to that.
Yeah, there was no alibi. There's no records that he was in another place, that someone was with him. Now, he doesn't have to give any evidence. He can just argue there's a failure to prove the case beyond a reasonable doubt. So let's not put the burden on him. But then again, if we're trying to really evaluate what happened here, you would expect some story about where he was during that time if he wasn't there. And I think one of the big things that I keep going back to is the victim here. What's his motive to either be incorrect or to lie about who shot him? He knew this person. He knew the defendant really well. The defendant had gotten him allegedly to sell drugs. And in fact, there were drugs in his apartment. The defendant knew him for a while, so he's not mistaken that, oh, it looked like him, but it was really somebody else. So the only explanation is he made it up. Why would he lie? Why? He was shot in the head. He didn't fake being shot in the head. So why would he then make up someone else? The defense really never gave a plausible explanation for that.
Maybe to protect his buddies. Let's go back and take a listen to the defense's closing arguments that happened earlier today. We are breaking down the Shaun Harrison attempted murder trial out of Boston, Massachusetts, here on the Law and Crime Network. And welcome again to those of you listening on Sirius XM satellite radio. We have Stacey Honowitz on the line from Fort Lauderdale, Florida. Dan Shore is managing director at Kroll and an attorney. Stacey is a sex crimes prosecutor. I want to throw a couple of questions on the table from these defense closing arguments. The first one, does it really work, Stacey, when a defendant who's opposing you in court cops to 3 charges and then says to the jury, we didn't do the rest of the charges? In this case, it would be 7 additional charges. Does that tactic work? We've seen it a lot lately. Or does it try to invade the decision-making province of the jury?
Well, listen, I mean, when there's overwhelming evidence that every count has been proven beyond and to the exclusion of every reasonable doubt, I think the defense feels like they have no choice, especially when ammunition and weapons and all of this evidence is found in the possession of the defendant. There's really nothing else to say. So does it work? I guess for some jurors, they might think, well, he wouldn't be confessing to this if it didn't happen, and he wouldn't be pleading not guilty if it didn't happen to this count. So it's a very hard tactic But I think when the defense is up against the wall, when the evidence is there, when there's really nothing else to discuss, and as your other guest mentioned, that they didn't even say where the defendant was at the time, which is the biggest hurdle to get over. I think that they really don't have a choice. And they copped to 3, hoping that one juror on that panel is going to say, well, he would have copped to the first one, too, if he had done it. So you just never know.
Of course, we do wonder if we're going to wind up with a hung jury in many cases like this. But look, Dan, the defense here, at least in the beginning of the closing argument, is making this all about a question of possession. You know, look, there was this storage bin in the basement. They're making the case that this was sort of a common area in the basement that a lot of people could have had access to in this building where the defendant had an apartment. And look, you know the rules with criminal cases. When police find something in a common area, there's all this finger pointing. Everybody's trying to say the other person really possesses it. It's the roommate. It's my neighbor who has to store something down there. It's anybody else other than me. It's another tenant. That's what the defense is really pointing the finger at here. But look, the prosecution said during its argument on closing that there were items in the defendant's apartment. So is this nothing but a red herring here?
I don't think in the end it's going to mean much because he is, as we talked about, there's 3 charges of possession that he's admitting to. So right off the bat, he's going to be guilty of those. And then we have the attempted murder charge, which there's really strong evidence against him. Whether he's convicted or not is the main issue here. Those other possession issues, you could argue about those, and maybe he'll get off on 1 or 2 of those, but ultimately it's going to come down to, is he convicted of attempted murder? And then you already have him on these possession charges. So I don't think in terms of the ultimate sentencing, these other lesser counts are really going to matter.
It's all about the attempted murder charge, or the Massachusetts analogy to that charge. Again, folks, we're talking about the Shaun Harrison case out of the Boston, Massachusetts area, the case where prosecutors alleged that a school administrator and preacher was living a double life as a drug dealer. He's accused of shooting a student in the back of the head, leaving him for dead. That student miraculously survived, got up on the stand and said, "It was my teacher, my administrator, who recruited me to sell drugs and then later shot me." Let's continue listening to the defense closing argument. We are talking, folks, about the Shaun Harrison attempted murder trial in Boston, Massachusetts. You were just listening to closing arguments from the defense from earlier today. The jury is in the process of getting the case right now. We continue to break down the arguments. Dan Shore is managing director at Kroll. He is an attorney as well. Dan, look, I'll admit that there's a credibility issue here because the victim who was on the stand here didn't point the finger at the defendant. At least initially, there's a couple different versions of his story floating around there. Is that enough for the jury to look at this case and say, look, the story's inconsistent. The story about this particular defendant came into things rather late. Therefore, we can't believe it.
It's certainly the strongest argument the defense has, so they're going to push that as much as possible, as you saw the defense attorney do that. I don't think it ultimately will win the day for the defense because there's overwhelming evidence that this defendant had weapons, had drugs, was working with this victim, and the victim says that he shot him. There's no reason that's in evidence for why he would make that up and lie, and there's no other suspect that's being offered as another possible shooter. So it seems really hard for the defense to be acquitted on that count, but certainly they've done everything they can with the evidence available.
This is an argument where a lot of facts are thrown in, and some of the facts get a little bit fishy. Exactly where was all the evidence? Was it in the basement in a common area? Well, was it in the apartment? The jury's really going to have to try to remember all of that. So we're going to continue to break that down, but I know you need to hit the road, so great to see you again, Dan. We'll catch you the next time.
It's always great talking with you.
Okay, well, I'm glad that you like to come back. So
absolutely,
we'll have you again. We're going to take a quick break, but when we come back here on Law and Crime, we are going to be continuing to break down the Shaun Harrison case. The jury is in the midst of getting the case. We will be in verdict watch soon. That's here on the Law and Crime Network. We'll join you again in just a few moments. Folks, we are waiting for things to pick up in a bond hearing for Shara Wright. She's the ex-wife of an NBA star, Lorenzen Wright, who was shot multiple times and died in July 2010 after he played 14 seasons for a number of NBA teams across the country. We are going to continue to monitor that bond hearing. We'll dip back in live in just a couple of seconds. But first, I want to bring Stacey Honowitz on the line with us. She's here from Fort Lauderdale, Florida. Stacey, pretty common for a defendant who's in jail waiting for trial to seek a modification of bond or to seek to otherwise get out of custody pending the trial. One of the arguments we usually hear is that, look, it's easier for a defendant to prepare for trial if the defendant is not incarcerated. But, of course, prosecutors like yourself vigorously go after these suggestions from the defense and say, no, look, public safety and the desire to basically ensure the defendant's appearance requires that the defendant stay behind bars.
Yeah, that's 100% right. A bond hearing, especially in a capital case like this where she's looking at murder charges, you know, it's very difficult for a judge to look out, hear this evidence and say, you know what, I'm going to let you go. The defense can make all the arguments they want about it's easier to prepare. A judge usually will tell the attorney, well, you'll just have to go to jail and talk to your client. But there's specific factors that the court needs to look at. Certainly, it's not just a blanket denial. We have seen cases where very high-profile crimes take place and the defendant is let go. In a bond hearing, what a judge is looking at is ties to the community. What are they? The crime itself, how heinous it is, the involvement of the defendant, prior contacts with the criminal justice system, family, all of those things that would ensure that this person who's looking at a severe penalty, which in this case is extremely severe, is going to come back to court. So the court has to weigh all these balances. They hear from the state, they hear about the charges, they hear about the defendant's contacts with the court, they hear about the involvement that the defendant has, and then the defense, on the flip side, will try to tell the court, here's why we know my client will show up. We'll give our passport. They have ties to the community. This murder took place 7 years ago, and this person hasn't gone anywhere. The cops were able to investigate, and she was still in town. So all of these things the court takes into consideration in determining whether or not prior to trial a defendant should be freed.
That sets up the basic parameters that we're watching now. Let's go back to this bond hearing again. We're watching a bond hearing for Shara Wright. She's the former wife of an NBA player who was gunned down in July 2010. That hearing is continuing in Memphis, Tennessee. Let's listen.